Assalamualaikum to Madam Ayuni and my classmate. Today, our group will be presenting based on the question given. Recognition means an individual employer is willing to accept the union as a rightful representative of his worker. Representation is so important in the collective bargaining process and in the interest of harmonious industrial relations. Discuss on the type of recognition and its process. So here is the group members, and my name is IZATTIE binti SHAFIEE. So I'm going to start with the introduction of the recognition. According to the Trade Union Act 1959, trade union refers to the combination of the union from employer and employer itself. And in Malaysia, trade union divided into three separate places, which is in Peninsular Malaysia, Sabah and Sarawak. Trade union must be legally registered first, then they need to get the recognition from their employer. Recognition is the most important prerequisite from employer for the collective bargaining. The importance of the collective bargaining can be seen when if the trade union get the recognition from their employer, then they may do the collective bargaining. But if not, collective bargaining cannot be conducted. Usually, the employer will delay giving the recognition to the trade union that on behalf of their employee because they think it will be impact to the collective bargaining, such as the employer will be more demand, like increasing for the salary and so on. Okay, next is the scope of recognition. Scope of recognition divided into two, which is the general recognition and the limited recognition. For general recognition, it represents the majority of the workers in the organization, which is more than 50.1% number of the employees in the organization that join the trade union. Besides that, for this scope, also all the employees in the organization, either join or not the trade union, will get the benefit that given by their employers through the trade union, such as get the bonus. In addition, for general recognition also has the power to do the collective bargaining because this scope is represent the majority of the worker in the organization. As one of the example for trade union in this scope is the QPAX, which is represent the public servant in Malaysia, and the total membership is 1.2 million out of 1.7 million public servant in Malaysia. For limited recognition, it only represents the minority, which is less than 50.1% number of the employee in the organization join the trade union. Besides that, it only gives the benefit to the members that joined the trade union and other members did not get the benefit. In addition, for this scope, it doesn't have the power to do the collective bargaining due to it only represents the minority of the employee in the organization.
Assalamualaikum, my name is NOORAYUNI binti JAAFAR. So I will continue with the types of recognition. So there are two types of recognition. The first one is voluntary recognition, which means an employer voluntarily agreeing to recognize either one or more trade union. Most of trade union recognition is being established in this way since it provides the parties with full flexibility and prevents them from having to use other alternatives that are potentially more difficult and complex. Next, when a trade union is being recognized for the first time by an employer, both parties will typically compose an agreement outlining how the recognition arrangement and the relevant negotiating or bargaining procedures will operate. The parties may periodically wish to update and revise their procedural agreements as the relationship grows. If the employer recognizes a trade union, he or she will have certain obligations towards the union and its members. This is an agreement on how the employer will conduct the collective bargaining. Such as an agreement could cover the issues of bargaining procedures and how the workers will be managing agreements and disagreements, specific matters like dispute resolution, working hours, salaries, and many more. Alright, the second type of recognition is statutory recognition, which means an employer does not voluntarily recognize the trade union. If the employer unable to come to a voluntary recognition agreement with the trade union, then it can make a written application to the industrial court for the legal right to be recognized by the employer. This only applies when the employer did not respond to the application within 21 days. Then the union may apply to do so. If the employer does not give the recognition or fails to respond to the application within the stipulated period, the union may make a report to the Director General of Industrial Relations. The Department of Industrial Relations will process the union claim recognition in accordance with the provisions of law. One thing to keep in mind is that the procedures for claiming recognition is a sensitive issue. Therefore, the way the recognition is given is very important in the context for future relationship between the employer and the union. Alright, that's all from me. Thank you.
Assalamualaikum, my name is NOORAYUNI binti Muhammad SUZAIRI. I will proceed to the next slide, which is procedure of recognition. What is procedure of recognition? It is the process that the trade union need to go through in order to accord recognition by the employer. This is important to make the union legally run to concern about the employee's rights and able to have collective bargaining with the employer. How to get recognition? As you can see in the slide, first, union should acquiring the requirements of recognition, which first to be legally registered union to ensure the DGTU can verify the union. Second, union must be competent to represent the employee's concern by having the knowledge in the field, skills to represent and ability to present. Third, union must be appropriate union to represent employees' concern which the union and employees' profession are related and in position. And the last one, union must have majority percentage, at least 50.1% of the members are the representative of the employees' concern. Move on to the next slide, which is application. Application is the first procedure of recognition. In order to represent workers, the trade union requires to submit an application form. Through this application form, the trade union can claim for recognition. Next, the claim must be made and submitted in writing and in the prescribed form. Then, after the trade union fill up the form, they need to submit to the employer. However, the trade union must make a copy of the form and forward it to the Director General for Industrial Relations, DGIR, as a record. Second procedure of recognition, which is employer's reply. The submitted application claim form must be replied by the employer. After receive the form, the employer has 21 days to respond, either grant the recognition or refuse to grant the recognition. Next, if the employer does not want to accord the recognition, the employer is required to notify the union in writing, which to inform the trade union. Next, as you can see in the slide, there are three possible responses. First, voluntary recognition, which the employer accept after receive and read the form. Second, refuse to grant recognition, where employer refuse and notify the union. And the last one, fail to reply, where the employer doesn't give any responses whether he agree or not.
Hi and Assalamualaikum. My name is Asyraaf bin Hashim and I'm going to continue about the procedure number 3, which is the report to Director General of Industrial Relations. So at this stage, the union must send written report to DGIR if the employer refused to or did not respond to the claim. If the union failed to respond, the application will be deemed that the recognition has been withdrawn. So this will benefit the employer. So when the written report has been sent to the DGIR, the application will be examined by DGIR to ascertain the union application. Next, DGIR will invite the employee to come out with the reason of why they refuse to accord the recognition or refuse to reply. Based on the process number 2 and the 3, DGIR will decide to conclude the case if the claim are certain and the reason are unacceptable. DGIR will advise the employer to accord the recognition and vice versa. If still the employer refuses to accord recognition, union must write the written report to DGIR for further action. Okay, next we move on to the procedure number 4, which is action by DGIR, and number 5, which is the ministry level. Okay, for the procedure number 4, when DGIR receives the written report, DGIR will review all the information from both parties, employer and the union. The employer should let them access all the information they need, as the DGIR are trusted authorized body secured by law. All the information will be secure and will not be exposed to the public. Next, DGIR will consult with DGTU in making decision. If both DGIR and DGTU found that the claims are valid, DGIR will again advise the employer to accord the recognition. If the employer still refuses to accord recognition, DGIR will send the written report to Ministry of Human Resource. And at this stage, which is ministry level, the ministry will review the issue reported and the minister will make the final decision, and the employer or the union must accept the decision and should not question the decision made by the minister. That's all how the procedure of union can get their recognition from their employer. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is NORSHAHFIQAH binti IDRUS, and I will continue with the next slide, which is the issues of the recognition of trade union. So the first issue that been published by the Ash Market, wrote by the Arif Manohar, is between the National Union Flight Attendants Malaysia versus Malaysia Airlines. This is because Malaysia Airlines refused to recognize NOFAMs as the representations of their employees, even though it has no problems with the DTIR or even the Ministry of Human Resources. So the issue became worse when Malaysia Airlines being charged by the court for denying their in-flight supervisors workers being employed in any managerial, executive, confidential or security capacity of Malaysia Airlines. So the court held that National Union Flight Attendants Malaysia's trade union recognition process can be proceeded with in-flight supervisors workers allowed to vote for NOFAM's representation on their behalf in the court. Next, I will move on with the second issues of the recognitions of trade union. So the issues that been published by Malaysia Kini, wrote by the Zikri Kamaruzzaman, is between the Industrial Electronic Union West Region versus Renesas Semiconductor KL Sdn Bhd. This is because the company is deliberately postponed trade unions negotiations. And for the further information, Electronic Union West Region are being formed in 2009, but the company refused to recognize this trade union in January 2010 and tried to form an internal trades union. And from this action, several problems has come out, such as the company is refused to negotiate with the collective agreements of the union, and second is the presidents of this trade union are being fired by this company.
In conclusion, it is very important for trade union to get the recognition to ensure they ever conduct the collective bargaining. In Malaysia, there are two types of recognition and need to follow the several process to get the recognition. Moreover, to get and give the recognition to the employee is very important to create the win-win situation for the employer and employee, so it can avoid the dispute in the organization. So that's all from my group. Thank you.